Hey everybody, Greg Rice. Not in the bucket today, all right? Not in Pawtucket. I'm actually in my home studio. Our office is being renovated. We hope that that's done in the next couple months. So for now, I'm recording videos here. And as you can tell, I don't paint my walls. I actually put up 10-foot large American flags on each wall. I save a bunch of money. But all jokes aside, today's topics are very serious, and I've decided to make a video and send this out. We have about 30,000 people that are in our email list, and they're all in the real estate community in some way, shape, or form. So I could have brought this to Leo, right, my state senator, or Patricia, my state rep, but in my opinion, the message would not be delivered in this fashion. So I appreciate you watching. And what I'm going to say to you is really a culmination of my own thoughts, our clients' thoughts, tenants, contractors, bankers, insurance agents, attorneys, you name it, that I've been talking to. So I'm going to try to relay that as concisely as possible. Now, before I get into the nitty-gritty, I want to preface this by saying that this video is not meant to ridicule, criticize, or poke at anybody, specifically, individually, politically, in any fashion, party-wise. None of that. I am not here to obstruct progress. I am here to make progress attainable, because right now we can all agree that it is simply not attainable to hit the thresholds and the requirements that almost 200,000 rental units have as of today. And today's October 9th that I'm making this video. The registry and the lead enforcement went into effect on October 1st, as we all know. And I've been inundated with calls, emails, texts, people that come up to me at the gym, in person, at the gas station. They're panicking. They're nervous. They're scared. They're worried. These people, they don't know how they're going to do it. They don't know step one, a lot of them. Some of these smaller landlords, some of these older landlords that live on fixed incomes, how are they going to pay for it? Where are the tenants going to go? Who's paying for that? There's just so many concerns that people have. So what I want to do is give you those concerns and propose a solution. Because I think that it is absolutely disgusting that almost 50 years later, we still have to deal with this as a society. It's a failure on our part as private landlords, as investors, and it's a failure on the government's part. We both hold culpability, period. You cannot change my mind on it. We both have dropped the ball, because no children in 2024, think about that, we're in 2024. The last time lead-based paint was used, my dad graduated high school. And I love my father, but he's getting up there, right, in age. That's the last time it was used. And we still, in Rhode Island, have 500 children that are victims. These are victims. This isn't a, oh yeah, don't worry about it kind of thing. These children are victims for life, and it should not be happening. This should be 10, 20 years old, this issue. But we're still dealing with it. And we're gonna squash it. That's what we're gonna do. And this legislation, very gritty, very ballsy, and it's going to get us to that finish line. Through that finish line. The goal is zero. Or if not, as close to zero as possible. 500, that's almost 2 a day. Unacceptable. What I want to do first is go over, all right, both of these. The mandatory registry and the duties of property owners. Because a lot of folks, they're not reading this. They have no idea what it says. People are not involved, they should be. And I'm always advocating for people to get civically engaged. It's a beautiful thing about our country, about our state, right? Such a small state that you can make a large impact. If you're in a place like Texas, Alaska, California, you don't have the intimacy that we have in Rhode Island, and a lot of people don't appreciate that. I do, right? You have accessibility to different departments, different politicians like that. So we should be more engaged as a community, in my opinion. So I'm going to go through these, and I'll start with the rental registry. This is 341858. We'll put it up on the screen for you. And this one's pretty straightforward, okay? All landlords shall register the following information with the Department of Health. The names of the landlords, okay. An active business address, your email address, your phone number. If you have a property manager, their email address, their phone number, makes sense. All landlords who lease properties constructed prior to 1978 and are not exempt must provide the Department of Health with a valid certificate of conformance or evidence sufficient to demonstrate that they are exempt from the requirement to obtain a certificate of conformance, or evidence sufficient to demonstrate that they are exempt from the requirement to obtain a certificate of conformance. Now, let's set the record straight. The lead laws to provide these certificates have always been there, so long as I've been here in Rhode Island. This is not new, folks. This has always been here. What is new is the inability to file a non-payment of eviction case and the application of fines. Those are two new features. So now that they got you by the short and curlies, you're finally paying attention. Better late than never, okay? But in the government's defense here, this is not a new requirement. This has always been there, and I've dealt with it on many of my properties, okay, specifically in Woonsocket, and it's something that you have to do. This is not a new requirement, okay, so just want to say that. Next, subsection C here, contingent upon available funding, the Department of Health or designee shall create a publicly accessible online database containing the information obtained in the sections above, no later than 9 months following the effective date of this section, which was June 20th of 2023. And I think that this came online a couple months ago, so it's a little post facto, but nonetheless, it's up and running. All landlords subject to the requirements of subsections A and B as of September 1st shall register the information required by those sections no later than October 1st, which was 8 days ago. Okay. A landlord who acquires a rental property or begins leasing a rental property to a new tenant after September 1st shall register the information required within 30 days after the acquisition or lease to a tenant, whichever date is earlier. All landlords subject to the requirements of subsections A and B of this section shall, following initial registration, re-register by October 1st of each year in order to update any information required to comply with subsections A and B. Subsection E now. Any person or entity subject to subsections A and B of this section who fail to comply with the registration provision shall be subject to a civil fine of at least $50 per month for failure to register, or at least $125 per month for failure to register the information required by subsection B. All right, so here are the fines that I was talking about. F, all civil penalties imposed pursuant to subsection E of this section shall be payable to the Department of Health. Okay, there's to be established a restricted receipt account to be known as the rental registry account, which shall be separate within the Department of Health, and penalties received by the department shall be deposited into that account, and the monies shall be transferred to the Department of Health and shall be expended for the purpose of administering the provisions of this section or lead hazard mitigation, abatement, enforcement, or poisoning prevention. No penalties shall be levied under this section prior to October 1st. So essentially, they're going to use the money to mitigate, to abate, to staff perhaps, right? Maybe that's under enforcement, poisoning prevention, maybe public service announcements. They're going to kick it back into the program, and like I'm talking about speed up our pace to reach that finish line. So the monies will be used, in my opinion, in a good fashion. G, and we got one more after that. Notwithstanding the provisions of 34-1835, a landlord or any agent of a landlord may not commence an action to evict for non-payment of rent in any court of competent jurisdiction. They're all competent, right? Kent County could be a little tough, but they're competent, right? Unless at the time the action is commenced, the landlord is in compliance with subsections A, B, and D. A landlord must present the court with evidence of compliance, right, your lead certificate, at the time of filing to evict for non-payment of rent in order to proceed with that civil action. So now you're not registered and you don't have your lead certificate. You cannot file an eviction for non-payment of rent. You cannot do it. The attorney will not accept the case. The court will not accept the case. You're stuck. Okay? That's where you're at right now. The way this is written and the way it is being enforced. Final section, H. The Department of Health may commence an action for injunctive relief and additional civil penalties of up to $50 per violation against any landlord who repeatedly fails to comply with subsection A. The Attorney General may commence an action for injunctive relief and additional civil penalties of up to $1,000 per violation against any landlord who repeatedly fails to comply with subsection B. Any penalties obtained pursuant to this subsection shall be used for the purposes of mitigation, abatement, enforcement, or poisoning prevention, or for the purpose of administering the provisions of this section. So same thing that I mentioned above. No penalty shall be levied under this section prior to October 1st. All right. So that's that. That one is pretty straightforward. What I disagree with is that if your property is built after 1978, you should not have to register. And the way this is written, you do have to register. So the state will say, well, you need to register in order to prove that your property is exempt. So if your property is built in 1994, you upload documentation of that and you're all set. But I disagree with that because I think this might be a guise. There might be a larger thought, goal, mission with this registry. There might be a candle that the state wants to hold under each and every property owner just to keep tabs. I don't know. Okay, I'm speculating. But in my opinion, if you're post 1978, you should not have to register. Period. And if you do go for an eviction, you have that affidavit, right? And it says, I'm exempt. And at that time, you provide your tax card, right? Or something to show that the property was built when it was. And that matters to bed. And you may not even ever have an eviction, so you might even never have to do that, right? It's just superfluous at that point. But the way this is written, to me, says every single property in the state, regardless, needs to be on it. And that is a little suspicious to me, okay? So, I think we've covered that fairly. Second piece now, this is the detail. 42-128.1-8, duties of property owners of pre-1978 rental dwellings. So property owners of pre-78 dwellings which have not been made lead safe or have not been lead hazard abated shall comply with the following requirements. Number 1, learn about lead hazards. Number 2, evaluate the dwelling unit and premises for lead hazards. Number 3, correct identified lead hazards. Number 4, provide tenants basic information about lead hazard control, a copy of the clearance inspection, and information about how to give notice of deteriorating conditions if they notice things. Number 5, correct lead hazards within 30 days after notification from the tenant of a dwelling unit with an at-risk occupant. So what I just read took me a minute. What it will really take for a landlord to accomplish, maybe years. what I just said, from learn to correct, it's going to take years. And just to do some math here, math was not my strong suit. I really liked, I was more of a history, civics, philosophy kind of guy. I didn't really like math, language arts, the crucible. So we have 200,000 for simple purposes rental units in the state. There's I think there's 37 approved lead inspection companies, and I think like 6 or 7 of those are private only. I think they just work for the state. So roughly 30 companies are available to be hired. You divide that. Wow. I'm not superstitious, but this is a little odd. If you divide 200,000 by 30, you get 6,666.666666. So the point here is the amount of units versus how many companies can service those units is just way beyond Pluto. Way beyond. 6,600 units for one company to handle. Divide that by 365 days. I mean, that's like 20, 25 units a day that they would be handling. The staffing, the infrastructure, just the labor, the intensity, the time. It's just not sustainable. Going back to my monologue in the beginning, it's just not possible, even for the companies, to adhere to the customer demand. And on top of this, if you want to become a lead certified inspection company, you need to apprentice, right? You need to go under another inspector and learn the trade and become that person. That takes time. It takes a lot of time. In my opinion, for 200,000 rental units, say there's 250 companies. That would be 800 units per year that they would be responsible for. It's about 2 a day. That's reasonable, all right? That's possible, rather. Right now, we're almost 8 times that amount. Okay, these companies aren't even accepting new clients. LeadSafe, Sharon Barr, an absolute scholar, businesswoman, she's on her game. Last I heard, she's not accepting new clients. So we have people who want to follow the law, can't follow the law. And we have companies that can't service the demand. They're just up to their eyeballs. They can't even do it. So imagine, let's put this in simple terms. Say we have 200,000 vehicles in Rhode Island. They all need to get inspected. We have 30 service stations. Just picture the line of cars down the road, like the oil embargo in the 70s. That's what we have now with the lead laws. We have an absolute rush at the door for people to comply. So compliance is not an issue. And that's one thing that I want to get across here. People want to comply. They can't comply. Okay? That's a very big difference there. And they're going to be penalized financially, right? And time-wise. You can't file a case. So what are you going to have? You're going to have a rush of termination cases. All right, landlords are going to terminate tenancies, which is going to take longer. It's going to cost some money. And then the tenant's going to be displaced. And then the rents are going to go up $200 to $500 a unit easy, because the landlord's got to recoup their losses. And you're going to have a rush of homelessness. You're going to have a rush of rental raises. Okay? It's going to be a disaster. Not to mention, landlords that can't pay their bills, you're going to see one of the largest influxes of foreclosures and delinquencies. The rates are going to go through the roof. Cities and towns, their tax rolls are not going to be 100% funded. People are going to stop paying. When push comes to shove, I'm going to stop paying my taxes. to stop paying my mortgage. I have to do this first. And people say, oh, well, that's, so what? The city will sell them, recoup the property. Yeah, but we don't want to go there. We don't want to bankrupt landlords and force tenants into homelessness. We don't want to do that. So what I'm asking and calling for is a phased approach into this enforcement. And I believe we need a 24-month moratorium effective immediately on these laws. The registry is fine. You can keep that. Everybody's got to register. Pre-78 construction, in my opinion, but if that's not amended, everybody registers, okay? But the lead certificate is simply not obtainable for 200,000 units. And you can say, Greg, these people have had a year of notice. Yes, they have. But still, that's not enough time. Even if everybody was on their P's and Q's, that's still 6,666 units that Sharon Barr and her company would be handling. It's just not feasible. So, moving on, new property owners of pre-78 rental dwellings that is occupied by an at-risk occupant shall have up to 60 days to meet requirements for lead hazard mitigation. If those requirements were not met by the previous owner at the time of transfer, provided that the new property owner has the property visually inspected within 30 days after assuming ownership to determine conformity with the lead hazard control standard. Section C here. The requirements for lead hazard mitigation shall apply to the first change in ownership or tenancy after November 1st, 2005. D. If the tenant receives no response to the notification to the property owner of deteriorating conditions affecting lead hazards, if the response is in the tenant's opinion unsatisfactory, or if the remedy performed in the tenant's opinion is not satisfactory, the tenant may request a review of the matter by the Housing Resources Commission. And after the review of such matter, the Housing Commission shall either send notice to the property owner, in which notice shall be issued in a manner substantially similar to a notice of violation issued by the director pursuant to the Housing Maintenance Code, Chapter 24.3 or Title 45, or promptly inform the tenant of the reasons why the notice is not being heard. That's a dense one. So what I see in this section is, a couple things. I see tenants that are going to play hardball and they're going to say, to the commission, I got this problem, landlord never came to fix it. And the landlord is going to get notified and be like, what? Tenant never told me. Tenant's just going to try to cause a rift. Or tenant could point something out, landlord could come, and then, you can't come in right now. Oh, it's not a good day. Oh, it's not a good time. And the landlord's going to be up against it. Tenant's going to submit to the commission. Commission's going to go after the landlord. He's going to be like, or she's going to be like, I went there, tenant wouldn't let me in. But they have to prove that, and the tenant's got the leverage, in this situation. And also, I think some tenants will know what's going on here and just stop paying. Right? Oh, he doesn't have his lead certificate. She doesn't have her lead certificate. I'm going to just stop. And technically, they're right. The landlord should have it. But it's just another notch, right? It's another axe that the landlord has to fend off. Not only do they have to get the units into compliance, but now the tenant just decides that they're going to stop paying because they know the landlord can't file a non-payment case. And this is not going to be the overwhelming majority, but it's going to be there, right? When you create something like this and create a logjam, people are going to exploit it. That's just human nature. Think about unemployment insurance fraud during COVID, right? It was a rush to get people money as quickly as possible, and people that were not ethical, like you and me, chose that as an opportunity to exploit. The same thing is going to happen here, okay? Section E, notwithstanding, love that word, or attached hereto, the famous Michael Crane email subject. Mr. Rice, attached hereto. I feel like he writes it with like a feather pen, dips it in his ink. There's a candle attached hereto. Notwithstanding the foregoing, The provisions of this chapter shall not apply to common areas in condominium complexes. Hold your horses. You thought it meant your hallways. No. We're talking about condominium complexes that are owned and operated by condominium associations or to pre-1978 dwelling units that are, drum roll please, number 1, lead safe or lead free. Number 2, temporary housing. Number 3, elderly housing. And number 4, comprised of 2 or 3 units of which is occupied by the property owner. Or the Department of Health shall report to the legislature annually on the number of children who are lead poisoned in any of the exempted dwelling units as referred to in subdivision E4. So maybe the state's going to be looking at that and saying, all right, with this exemption, are children still being impacted? So maybe those exemptions could become exempt. They could be removed, right? Because the goal is 0. So if those are still causing issues, that's how I interpret that. I could be wrong. And finally, nothing contained herein shall be construed to prevent an owner who is seeking to obtain lead liability insurance coverage in the policy from complying with the provisions of this chapter by securing and maintaining a valid and enforced letter of compliance or conformance in force. That's it in a nutshell. And again, thank you for watching. It's something that we just need to think about. Is this feasible? Are people able? Are they willing? Yes, landlords are willing. The ability and the feasibility are not possible at this moment. And then also we have to consider, what is this going to do long term, right? What are going to be the negative outcomes of a rapid and strict enforcement like we have now compared to a phased and sustained approach? And like I said, I feel 24 months is a fair compromise to not only get people on board, but to get companies on board, right? The message is out there. People know registry, lead, it's out there. The ability for people to get out there and do it is just not. Okay? They want to do it. They have that, but they're not able to meet those needs and those requirements. We are going to be penalizing thousands upon thousands of good-hearted, good-natured landlords that are simply off guard by fault none of their own, right? With the staffing of other companies. And we also need to consider, say that every property was in conformance. The companies that are available could not even maintain keeping those properties certificates in line. It's just not sustainable. It's not possible. It's not physically possible. And like I said earlier in the video, privately and publicly, right? Us landlords, the government, the infrastructure is just not there yet to have something like this in force. It's admirable. It's diligent. It's necessary. But we need more time, respectfully. And I'm speaking on behalf of, like I said, landlords, banks, insurance companies, contractors, right? We didn't even get into, oh, right, your unit has lead. Now what? Right? I didn't even get into that. That's a whole nother ball game. Right? Where's the tenant going to go? Who's paying for that? How much are the repairs? Oh, you got to take the sheetrock off? You got to take my windows and doors out? Oh my God, it's going to be $100,000? I can't afford that. I didn't even get into that because that's, at this point, not even relevant. Because this needs to be implemented. I get that. But we just have to look at how much are we dumping onto our citizens at one time. And how would you feel if this happened to you, right? If this was your main source of income. And for many of you watching, it is not. Okay? It is a supplement, right? It's a retirement. It's a legacy item for some of our older landlords. How would you feel if your whole business was upended like that? And they're not even asking for financial help, right? It's not even about that. Some are, but the majority just, how do I get into compliance? How do I make sure I'm following the rules? That's the consensus that I'm getting and hearing from people. I think I've made that point pretty clear. We just need to give them more time to get there and for things to catch up to where it's like, all right, we can breathe here on all sides. This makes sense. People understand it. People are aware of it. And getting this into the public conscious is no easy task. But the state's doing a great job. There's plenty of advertisements. I've seen them on Rip the buses, for God's sake. They're out there. So people are knowing and seeing and hearing, but we need more time. And it's very obvious it's going to cause a major bottleneck in so many different departments. And at what expense, right? At what cost? We could say, yes, children are being poisoned. Okay. But just with this situation alone, I can assure you that next year's number will be going down. And it's a race to zero. And how do we get there? Ethically, fairly, and reasonably. All right. So thank you for watching. This was longer than I thought. I thought I could do this in 15, 20 minutes, but I think I'm double that. And if you have any questions or any feedback, let me know. Greg Nexus Leasing, you give me a holler at gmail.com. That's all I got. So once again, Greg Rice from Nexus Property Management, not in the bucket. Your property managed.